Good evening. Prior to the Planning Commission meeting tonight, we have two public hearings. The first public hearing is regarding the establishment of a Waukesha County shoreland and floodland protection ordinance jurisdiction over an area extending 1,000 feet from the ordinary high water mark of a navigable pond as determined by the DNR. The proposed county zoning districts are the A2 Rural Home, EC Environmental Corridor Overlay, C1 Conservancy Overlay, HG High Groundwater, and A1 agricultural districts, all located in the southeast quarter and southwest quarter of the southwest quarter of Section 25 and the northeast quarter and the northwest quarter of the northwest quarter of Section 36, Town 7 and R18 East, Town of Delafield.
All right.
The county or town?
I'm going to go first.
Okay.
And then Rebecca is going to join in when I'm completed with what I'm going to present. So basically, this is the portion that's on the map behind me indicates the location of the shoreline district. You can see kind of a loop that's a little bit to the north. That's the current boundary of the shoreline area. Now this colored section is the portion that's going to be added to the shoreline zoning jurisdiction. It's located at the east end of Sylvan Drive, which is, let's see, is that showing up? That doesn't show up, okay. And so what happened is there's a pond that you can see kind of in the center of this drawing that was determined to be navigable by the DNR about 4 years ago. State law provides that if it's a navigable pond or lake, then the county has shoreline jurisdiction within 1,000 feet of that particular body of water. The county is in the process right now of formally recognizing this as the shoreland zoning district and applying the county zoning to that. So what you see here is there's two small pieces of A1 in the light brown in the southeast and southwest corners. There is kind of the darker brown, that's the A2 Rural Home District. There's high groundwater, that's in the green you can see there. There's and that's based in an area that has pellet soils, which has high groundwater. That's based on the high groundwater of the soils. And then there's also C1 Conservancy, that's basically mapped wetland. And then there's environmental corridor that corresponds with the environmental corridor, which is prepared and mapped by SewerPack. So the town zoning prior to the navigability determination was A2 Rural Home District. I had talked in my report in here that there was a small area in an initial map that you might have received that was A2. Formerly it was A1, and so I spoke to Rebecca and she provided that updated drawing that you saw prior to this slide here. That was that showed that parcel being to remain A1. So I think that's, I'll let Rebecca fill in any gaps then on that.
Hi, good evening. The only thing that I would just add is the differences between the A1 district and the county and the town are relatively minor. The biggest difference is that the town's A1 zoning requires a much larger lot size. It's 20 acres, whereas ours is only 3 acres. And I just wanted to point out that that doesn't, based on the two small corners there that are going into the county's shoreline jurisdiction, it really wouldn't allow these properties to subdivide a 3-acre portion off, mostly due to access issues for both of them. So I just wanted to point that out as well. There's 19 properties that are overall affected. One of them, they're all developed. All the residential parcels are already developed. Some of them are going to entirely be encompassed within shoreline. Some of them just, like you can see on the north end, they're already mostly in shoreline, and just the remaining tidbit is now entering into that jurisdiction. The only ones that are not developed yet are the lots in the retreat subdivision there to the south. That middle one is actually an outlot, so it's only 2 residential parcels. And when that was platted a few years ago, we knew this was forthcoming eventually, and it says right on the final plat that it'll be in the county shoreline jurisdiction, so there shouldn't be any surprises for anyone, so.
Okay, this is the public hearing, so if anyone wants to speak, you should have gotten a little card at the entranceway. Hand it to Dan, and you can speak if you'd like. Okay. Sure. It's A1 town now, but it's going to be A2 county, I think. I don't know. We can ask. That's a good question. Or is that the one that's?
It's the one that's up there.
No, see, that's the correction they made. Now it says A2.
So this is wrong.
Yeah, this one is wrong. That's the updated one.
This
right?
isn't, this is the updated drawing. The only difference is this little piece right here is now A1.
The yellow's A1.
Yeah, but this one says that the middle section, the retreat is all A1. And now it's A2, right?
No?
Here, look at it too.
Right there, it says A1. And that one says A2.
The portion in white, does it say that? I'm sorry, I can't.
I believe that our mapping technician noticed that error. The color is correct, but the label transferred
yes.
over odd because
Yeah.
under the way that the county's mapping works, the town actually has their map underneath ours, so that A1 district was coming through. So that's an incorrect label, but the color is correct if you're looking at the legend.
Okay.
So it is proposed to be A2 in the retreat subdivision, similar to how the town now has that zoned following.
So this is not accurate. What was in our packet is not accurate.
Correct.
And it doesn't have.
Well, based on that little corner, the labeling's not correct, but if you look at the legend of the
Yeah.
colors, that is.
This changed
That
and
is
this
correct, yeah.
changed.
So if you
That's
notice,
always
the
been
color
A2.
is not different
That's
on
always
those
been
3
A2.
parcels. It's, the label was different because the town of Delafield's zoning as how the county had it.
Retreat A1?
It used to be before, yeah.
Okay.
The
so
county
we-
was not, yeah, we
So
weren't
even this
notified.
map where it says, you said it's the overlay of the town map, it wouldn't be, because that would have
The
been.
county was
A2.
not notified of that
Oh.
rezone to update our layer because you don't use us for that, so we have to we have to actively be notified to update that town zoning layer map,
Okay,
so.
all right. Yep.
I just need some things clarified. And it's basically for you to clarify exactly on the retreat, the 2 in from G on the A1 has the lighter color in the corner. And then it has behind it the 2 darker colors. And is that the water or what? Because from back here, it's hard to tell what it really is. Can you explain that clearer, please? Maybe you can go up there and show it.
Yes. If I speak loudly enough, is that okay? Yeah, that's fine. Okay. So this portion here, this corner of this larger farm parcel is proposed to be A1 in the county shoreline jurisdiction, which mirrors the A1 under the town zoning jurisdiction. This is the boundary of the retreat subdivision here, which has been rezoned to A2 when that subdivision was platted under the town zoning jurisdiction. So these 3 parcels that are now under the county zoning, that would be under the county zoning jurisdiction, will also be A2 rural home district. So it again is going to mirror the town's zoning jurisdiction for that agricultural rural home district.
And that's A2.
Correct, that is A2. This is an outlot that's owned by the retreat subdivision owners. So it's this residential parcel and this residential parcel are the only 2 that would be owned by individual property owners that would actually be developed for residential use. And then this is the A1, that was an accident as well. This should have been A1 initially, and I had missed that little piece of all the conservancy that's over it. This little piece is A1, mirroring the town's A1 agricultural district. It's a very small little corner of that farm parcel.
Does anyone else wish to speak? Okay. Close the first public hearing. Second public hearing is a request by Dan Studer, W289N106 Elmhurst Road for a zoning amendment to the Waukesha County Shoreland and Floodland Protection Ordinance from C1 Conservancy Overlay District to A2 Rural Home District to accommodate a residential driveway for a future home located south of his residence.
All right, so there are two small parcels that we're going to talk about. The first one, as you can see on this map, is about the center of that property. It is approximately 1,095 square, well, the calculation is 1,095 square feet. And that would be under the first discussion, that would be rezoned to C1 because it's wetland. The proposal is to rezone that to A2 under the county's jurisdiction, shoreline jurisdiction. The second parcel, this one's up on the north side. It's at the east end of Sylvan Trail. And that parcel, that small parcel in there, I know it's hard to read, but it's 260 square feet. And that's actually in a location where there is currently a driveway. However, it was wetland. Apparently, it was mapped wetland at one time, and so this will be a way to, it's basically the request is to do an A2 to accommodate that driveway. Actually, both properties are to accommodate that driveway there. The entire property for the Studers is 11.38 acres of land, and they have access to Elmhurst Drive. By rezoning this, the potential is that there would be access from the end of Sylvan Trail to the east side of their property that's located in what's known as Lot 1 there. And so they would potentially have access to that and potentially be able to site a house there in the future, or at least get access to that east side of the property. I think that's all I need to give as an introduction, but Rebecca, if you have some more.
So as Tim said, the C1 Conservancy District applies to all the wetland areas on this property. The C1 district allows for normal driveway construction in order to provide access, provided that such facilities are deemed essential, or provided that the failure of existing driveways would endanger the public health or safety, or just not otherwise be accessible. So this driveway is being proposed solely to accommodate a future potential land division to a 2-lot CSM, as he already has access to a residential home site on the west portion of the property. So the area of fill is relatively minor. It's about 1,300 square feet. The total wetland acreage on the property is about 0.85. So it is a relatively small area. The north portion has already been filled in back in 2017, 2018. Prior to county zoning being known, the DNR had granted approval of that when it was under town zoning. That was just A2 zoning. So we are accommodating that request as part of the one to the south to actually get to the residential home site. As part of the land division, it would require a building envelope to be established on the certified survey map that would limit disruption of the isolated natural resource area. The county's comprehensive development plan does have this property as isolated natural resource area, which requires 5 acres per dwelling unit. Given the property is 11.3 acres and the wetlands are only 0.85, he does have adequate upland area to propose this land division for 2 lots. Which is part of this accommodation here. So, let's see. The CSM, when that is proposed, would also require lot not abutting a public road approval, which we do seek input from the town on that as well. And SewerPAC did the wetland delineation back in August of 2018. As part of their wetland delineation reports, they do an aerial, a historic assessment using aerial photographs of what the land was. In their 1970s aerial, they indicate that the subdivision just to the north here on Sylvan Trail is currently under construction. The road's been built, the ponds were excavated, and around the eastern end and the northeastern leg of this subject property, there was the placement of dredge soils around the pond. They said that that was evident. So these wetlands were, it was prior cultivated land that has become wetland over time with the help of the construction of the subdivision back in the 1970s. So.
Did you say at the beginning that in a C1 Conservancy overlay, you could put a driveway in?
We do allow that if there's no other option.
Then what do we need to rezone this for?
Because he currently has a driveway to a residential home on the property. So in order for him to even facilitate a proposed land division to get a second access, because no additional access points are allowed off of his current driveway, he would need to rezone the C1 to A2 to an upland, so an upland zoning area.
Oh, so you can't do a
accommodate that.
you can't do a driveway in C1?
If you have an existing driveway, you can't do a driveway.
Right.
Sounds like he's got an existing driveway, and that's why the C1 won't allow it.
So it would facilitate a land division.
Okay,
So, does that make sense?
sure.
Okay.
Well, the land division can't utilize the existing driveway, just extend it?
It cannot, no. There are incredibly steep slopes from that driveway down to where the building envelope would be in this area. They have to be, we're going back to 5-acre density, and then there's bigger lot sizes too with the corridor. So even if you wanted to create a parcel, say closer to that road, it's actually a private easement that I think it's either 3, it might be, I think it's 3 people use that easement when there should only be 2. 2 people? Okay. So they're capped out anyways. We wouldn't allow any further access onto that easement. It'd have to be a public road.
Thank you.
Sure.
Rebecca, could you just clarify one item that you stated, which was that the lot, for the CSM, the lot, they have to get approval for a lot not abutting a public road? So you would not consider the end of Sylvan Trail where they have 66 feet? Would that be considered abutting a public road there?
It's a flag lot. So that's what we classify lot not abutting a public road under. So any creation of a flag lot, again, because they already have access via another flag on the opposite side, they're creating a brand-new parcel that is solely accessed via a flag. So they would need that additional approval from the County Park and Plan Commission, and the Shoreline Ordinance seeks input from the Town Plan Commission as well, a recommendation from them for that approval.
And did I hear you correctly state that the wetland was created when the Sullivan Trail subdivision was created, when they put the dredge?
The ponds were dredged at that time. That doesn't necessarily mean that the wetland was created. The wetland could have been created over time. And SERPAC did note in its report that they're moderately susceptible wetlands. So they have like 3 different tiers of wetlands that are really used for impervious surface setbacks. The county doesn't, the planning and zoning division doesn't follow that. We have a strict 75-foot setback. But they did note it was a moderately susceptible wetland, which means there's a certain quality of plants in that area.
Anyone wishing to speak at this public hearing, please hand Dan your card and come on up.
My name is Keith Kindred, and I guess this flag is making the flag out of my lot. I'm in the center of this. I saw this coming in 2016. I petitioned the DNR for navigability determination of the pond on my property in May of 2016. I copied the county on that submittal. They did not do that. In the fall of 2017, I was given a call by my neighbor across the street that asking what I'd been chainsawing for days. And I hadn't been chainsawing for days. It was Thanksgiving week. I was up hunting. And got back Sunday night. Monday morning, we were met by bulldozers driving through the wetlands, filling the wetlands that he's now asking permit to do. I emailed Tim Barbeau. Tim Barbeau stopped work on the driveway, which he should have done. A permit was granted to build the driveway by Leif Hoggy under the false pretense that a road used to exist back there. There has never been a road back there, and I can have the farmer that's been farming this land forever tell you that. If you look at the historic photo from 1970 when these ponds were dug, that berm of dirt is a spoil pile from the ponds. It is not a roadbed. And the permit was given believing it was a roadbed. Now, the intent is for a flag lot. The intent is for a double flag lot. It's my understanding that this property was going to be developed before, and the same plan commissions denied the same concept. I've been in front of this plan commission for flag lots on Highway 18 that were denied that looked almost identical to this, but there was no environmental corridor and there was no wetlands involved. So the plan commission does have the right to deny flag lots, and they have historically denied flag lots. So now we've taken this backwards approach at land development. We've got a developer coming into this community, cutting down trees, grading, building driveways, and now begging for permission after the fact to fill the wetlands in a hardship that he's created. Why didn't he come here at the first point? Why didn't he come here day one and tell you, this is what I want to do, will you support it? But he didn't. Now, there's been a lot of water caused by this. I was under the impression when this berm of gravel was put down my north and east property lines that I would experience more water. I really thought that that would dam water coming off my property. I contacted the county. The county didn't believe that was going to be the case, and I have not noticed that. I'll be honest with you, I've not noticed that my ponds are flooding more, though, my house is relatively close to those ponds. It's always a concern. There is more flooding on the other side of the road, and Sean, who lives there, will tell you about that. He can also been farming this land, and he can confirm that there's never been a road back there. This is not an old road bed that was restored. This is the spoil piles of a pond. Thank you.
Anyone else wishing to speak?
Sean Barris, I'm on the other side of his easement going through. Since the driveway's been put in 2017, I have experienced more water in our retention pond, in our backyard, in the abutting farm field behind it, in the Wetland Conservancy, which is marsh grass and other wetland native species. This was never a road. I've lived there for 16 years now. Was never a road, ever. It was a path through the woods that deer traveled on, and that was it.
Anyone else?
So, I'll just talk for a minute, but Dan Studer can be here. Dan wants to split off the parcel of land, wants to split the parcel in two for his homestead, wants to downsize and retire and build it. And we have seen all the paperwork. In fact, Dan has 9 pages of typewritten paper as far as the timeline goes that I'll give you. And the land, he's talking about like a flag lot. The land is actually under the jurisdiction of the county, if I'm correct.
The flag lot?
Yeah,
Currently,
yes,
a very, very small portion of it.
right. But I mean, it's because of the wetlands, I was told that the property is under the jurisdiction of the county.
The wetland areas are immediately established as county jurisdiction upon that DNR determination.
Yeah, yeah. And I think that Dan's had that all delineated and located.
Delineated and surveyed, yes. With the aerial photography from 1970, there was not a road bed back there. There was a driveway that was created, and there was for access to the back of the property. It shows on the GIS mapping that it was being used. I mean, it's quite obvious on the Waukesha County GIS mapping. Not saying it was a road, saying it was a driveway. So that first, I'll address the water first. Most of the time, the area back there is pretty dry. There is a conservancy on, I'm sorry, I don't know the gentleman's name with the beard. There's a conservancy on his property that's identified in the Waukesha County GIS mapping that it's actually has a special area identified around it. And as far as water accumulating in there, I know he's been back there with machinery digging in that conservancy area right below his tree stand. So he's modified that. And then as far as Keith has noted that he hasn't noticed any increase in water by his house. And that's absolutely true because the water flows from the north to the south. So that driveway would actually prevent water from, invading on or encroaching upon his property. And also, there's a swale or a culvert along the side of this driveway that was created when they dug to the west, where the overflow water can go around and run down. So the water issue is this driveway has nothing to do with anybody else having any extra water because the water will flow around the side of the driveway that was created when the swales were dug. It'll just go right around here and run along the Shane said sister's property. Or it can go through the culvert that's in the driveway. And then, of course, when we come across the other side, Leif Hagee said he wanted a 24-inch culvert put in there so water can continue to flow.
You did have the permit from Leif.
And then, right, yep, so I addressed the water issues. As far as the permits go, we handed a timeline. And basically, I did have all the permits that I was informed that I needed. I got on the timeline, it starts in 1970 when this swale was dug, the driveway was created, not a roadbed driveway. In 2005, there's a CSM number 6889 that identifies the driveway and calls it an easement access for the back portion of this property. The previous owners did try a split, and the town board did approve the split with contingencies. And the ladies decided not to pursue it because the town board wanted some land deeded to the town, and the ladies didn't want to give up any land. Now, with this being a navigable water on Keith's property, we fall underneath a different requirement, which now would allow the splitting of the lot and the access to the lot. September 2017, I discussed the ordinances and requirements for the retirement home because I wanted to start this 3 years ago. And I wanted to have a garage put back there with a foundation. And now getting ready to retire, I would add on to that garage for my retirement home. Obviously, that all got delayed. But anyways, in September 2017, I discussed ordinances and requirements for the retirement home location and the driveway with Tim Barbeau. Tim stated I needed to receive authorization from Travis Schroeder for the driveway, and the town would be contact the town to put in the culvert. That was in September 2017. On November, so it was all discussed, planned, and I thought I was following all the ordinances and all the requirements. On November 24th, I met with Travis Schroeder to confirm the project was clear to proceed. He stated it was. We have documents from him stating so.
Travis is with the DNR.
Yeah, I'm sorry, I don't know if you know who Travis Schroeder is. DNR Wetland Management, I believe is his title. November 27th, 2017, the contractor cleared the driveway that was created in the 70s, cutting the roots from the, and then November 27th, they were stopped. On November 27th in the afternoon, Jacob Hermes from Waukesha County came out to see if I was in the Waukesha zoning from Eder Lake, and he confirmed that the driveway going in was not in that wetland management zone at that time. So I was good to go that way. So, and he said we're okay to continue. Travis Schroeder confirmed that we were okay to continue. November 28th, Leif Hagee, or however you say his name, Hague, issued a stormwater permit for the completion of the driveway, including this part to the west that goes back up towards the build site on the north end of Keith Kendrick's property. On November 28th also, culvert and fill was laid because Jacob Herman, Travis Schroeder, Leif Hagee, and Tim Barbeau didn't have any objections to that proceeding. Also on November 28th at 8:04 p.m., I received an email from Tim Barbeau Tim Barbeau sent an email to Travis Schroeder and myself that Keith requested a navigability assessment on November 28th, 2017. I have emails are all intertwined in this 9-page document. On November 28th, I informed the contractor that the driveway was on hold until permitting information was rectified. November 29th and 30th, that's when the contractors were scheduled to go to the west, build it, because we had the permit from Leaf. Jake was good with it, Travis was with it, everybody was in concurrence that all the ordinances were being met at that time. Yeah, so anyways, on the 29th, I told it they were done. The contractors were out there for 2 days. They were out there after I received permits and I was allowed, and I was under the impression from 3 different department heads that it was okay to go ahead and do it. They went out there, they cut the roots, they were stopped. They all got together, they said, yeah, you're good to go. So they came back the second day. They put down some gravel on top of the old driveway to build it up. And then I got that email saying that Keith requested a delineation and everything. Nothing, the driveway hasn't been touched since that day, since November 28th. Since then, I can go on and December 3rd of 2017, Christine Femo, Waterway and Inland and Wetland Permit Intake Specialist, reviewed and accepted my application. December 5th, the area on Keith Kendrick's property was deemed navigable by Travis Schroeder, which then put us into a different category, and I've been working on this slowly. January 2nd, 2018, the water management specialist waived the wetland requirement, issuing permit, and approved and acknowledged Leif Hagee's permit, so I could continue to the home building site. I have that email, it's included in this packet. February 1st, 2018, the Army Corps of Engineers, Melissa Jenny, approved filling the drive to the build site. September 13th, 2018, the wetland delineation was performed. September 17th, 2018, I had an email from Jason Fruth, which is also in here, that said he's attaching an application form that can be submitted to our office should you wish to pursue the lot not abutting authorization. That statement and a subsequent conversation I had with him gave me the impression that if I wanted to pull the plug on this project, I could, and I waited to get the delineation surveyed. I misinterpreted his meaning, perhaps. April 18th, the delineation report was issued. April 22nd, we secured Land Tech to survey the wetlands. And now, March 2nd, 22, the survey's done. It's .87 of an acre surveyed, well under the 1.3 that's allowed. So what we want to do is we want to split the lot in half and build our retirement home down there. So once this is approved or discussed, that would be the next step. I'm set to retire in June, so I would like to proceed with the building of my retirement home. I don't need a two-story house anymore. I want a nice flat ranch. So,
Do you have any questions for Dan?
Guess not. Okay,
I'm
thank
sorry
you.
if I went too fast.
I have another copy of this, if anybody wants it, so.
Does anyone else wish to speak at the second public hearing? Okay, we'll close the public hearing and we'll call the Plan Commission meeting to order. All stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Item 2, approval of the minutes of May 3rd, 2022.
Motion to approve?
Second.
All in favor?
Aye.
Opposed? Okay. Item 3, communications, none. I assume still none, Tim? Dan?
Yep.
Okay. Item 4, unfinished business, none. Item 5, new business. A, Waukesha County Department of Parks and Land Use, rate consideration and possible recommendation on the establishment of Waukesha County Shoreland and Floodland Protection Ordinance jurisdiction and establishment of proposed zoning districts to include A2 Rural Home, EC Environmental Corridor Overlay, C1 Conservancy Overlay, HG High Groundwater, and A1 Agricultural Districts, all located in the southeast quarter of the southwest quarter of the southwest quarter of Section 25, and the northeast quarter and the northwest quarter of the northwest quarter of Section 36, Town 7 North, Range 18 East, Town of Delafield. So this is the first zoning change from basically town zoning to county zoning, right?
Yep.
Which is pretty much mandated by state law.
I'll just go forward to the recommendation. I think that we should acknowledge that the shoreline floodland jurisdiction has been established, and then provide a positive recommendation to the town board to rezone the properties as proposed. In this particular slide, it says subject to the modification, but I would instead say in accordance with the latest drawing provided by the county on that.
And the rezoning, just to be clear, is as C1 at this particular time for this particular proposal?
No, it's in the map. You bring up the map. There's
Oh, the-
A1, there's A2, there's C1, there's
Is that
EC.
mixed up on the map?
I mean, there's going to be 4 different zoning district overlays on this parcel. This is the whole
There's-
parcel.
There's 3 districts and 2 overlays on this. 3 base districts, and then the county uses overlay districts for environmental corridor and, what's the other one?
C1's a conservancy.
Yes, conservancy.
So there's A1, there's A2, and there's high groundwater. Those are the 3 base layers.
Yep.
And then there's 2 overlays.
So with any agreement on this relative to the second part of the second public hearing, are we making any motion with regards to changing that as part of this one?
No,
No.
that would be changing things back.
Sure, we were
Yeah.
taking step by step.
Yep.
This is just to adopt the zoning recommendations that the county proposed. And we're recommending to the town board to recommend to the county. Ultimately, we don't make the decision.
Well, I'll make a motion to approve the rezoning stated by and subject to the staff recommendations.
Okay.
I'll make a motion second.
Okay, any further discussion? All in favor?
Aye.
Opposed?
Nay.
Okay. Item 5B, Dan Studer, W289 N106 Elmhurst Roadway, consideration and possible recommendation to Waukesha County on a zoning amendment under Waukesha County's shoreland and floodland zoning from C1 Conservancy Overlay District to A2 Rural Home District. So this is the second public hearing.
Tim, I have a question. I believe it was Mr. Keith Kindred stated that we're making his lot a flagged lot by approving this? I don't understand that. How can we make, he already has access, assuming he already has access to his lot.
Correct, he has frontage, a short frontage on Sylvan Trail. So
But
if
that's
he,
not his main access.
No,
that is his main
That is
access, excuse me, that is his main access off of Sylvan Trail.
Okay.
And that's, nothing on his lot changes as far as where his frontage is on Sylvan Trail. There's only a short section of frontage on Sylvan Trail
So
on his
is
property.
he coming off the access easement that's shown on this map?
No, his parcel's right here.
Okay, so he's before that.
Yes, my driveway comes off that access easement. There's a temporary cul-de-sac easement and an access easement.
Mine also.
No, you may not.
Not, so you're looking at one of these maps here?
I'm looking at A, what was in my package, Exhibit A and Exhibit B
So Exhibit A shows an access easement,
on the north
and,
side,
and that's part of the Studer property.
okay?
And I don't have any basis on why that's noted as an access easement. It's actually owned by the property owner when you look at the tax maps on that.
It was listed as an access easement on the two prior CSM. Sean's lot and my lot both use that access easement for access.
Well, it's an easement from whom? To whom?
No, if both their driveways and the end of the circle are all on my property, and neither one of them have any documentation that they have authorization to go on my property, to cross their driveway on my property. I talked to Keith about it, and he said that he would be grandfathered in because the house was built back in the 80s or whatever. But both their driveways are across my property.
So I would have no access to my property?
That's correct, you have no access to your property, so.
Well, that's not, we're not.
Not for this discussion. Pull up the map.
I could ask, is the county recommending this?
We are waiting for the decision from the town. And I just pulled up the Register of Deeds certified survey map for the lot to the north there. The temporary access easement does overlay on top of the access easement. So he does technically have a little bit of access in the corner. You do too.
But you can see where the driveways both come into
Yeah.
both properties.
Oops.
Yeah.
Let me move that away. So when I pull up the property, the tax records for the property, that shows the boundary of the Studer property in blue there. And if we zoom in, sorry. The driveway to the north comes off of the cul-de-sac at this point, across part of Mr. Studer's property. And I think the driveway for Mr. Kindred is right through this corner of his property there.
The lot corners are both on the west side of both of our driveways.
There is a temporary cul-de-sac easement though as part of that subdivision that extends over this easement
Yep.
in the
And-
corners.
And an access easement created by both CSMs.
Okay.
There's one by 5891 that was created, and there's one that was by 6889 that was created along that 318-foot by 66-foot. The one says it's a, Sean's CSM 5891 says a 33-foot access easement granted to the lands to the east. 6889 calls it a 66-foot wide driveway easement, but doesn't say who it's granted to. My day job's a land surveyor.
I still don't see how we're making a flag lot.
We're not.
I still don't see how we're making that Mr. Kendrick's lot a flag lot.
Well, typically when I see a flag lot, a guy owns 10 acres, he divides it into 2 5-acre lots, and he makes a flag lot of his existing house. And that's fine, he's making a flag lot of my lot. So I'm gonna have a driveway down 3 sides of my property.
The shape is not changing, you're right, it's the fact that the driveway would be installed, but the shape is not any different than what it is
Correct.
today.
Yeah. Does the property owner or the applicant have any recourse to accomplish what he wants to do without getting this zoning amendment? How else would he access the division of the lots?
He would not be able to use that, he could apply with the county to extend that driveway there that Tim has his mouse on right now. But it's
One,
obviously all
two.
wooded, it's ISA natural resource area, so there's disturbance limitations that can occur on the property. And there's steep slopes.
Oh, it's too slopey. That's what, that goes back to my first question.
Correct,
Okay.
yeah.
So this is what he's asking for is the least disturbance of the natural resources to accomplish the division of the property.
Yeah, but we're not here to discuss the division of the property. We're just here to discuss the zoning change.
Yeah, the zoning change. Okay.
Any other thoughts?
So
Comments?
where's this wetland on the map that Tim's showing?
Where's the, you're looking for the mapping of the
Do a wetland
wetland?
overlay?
Yeah,
or a-
this wetland that the DNR found and that we gotta now give the county 1,000 feet of.
Well, the pond is this darker in here. This area in here is considered the navigable pond.
And it's a natural occurring pond that was dredged as construction of the subdivision.
That's correct. It's a pond that was dredged as part of the subdivision construction during that time.
Back in the 60s, it was farmland.
Well, I guess my question is, I mean, is it naturally occurring or was it man-made? I mean, because, I mean, that's my concern is this is a slippery slope as far as, you know, if, you know, we can come back and find some of these ponds that were
So
dredged.
you can't give us anything unless it becomes part of the official record, and if it does, it goes through Mr. Green.
Yeah, I mean, it's a valid point, but
This shows it as farmland.
the DNR has already made the determination,
Well,
so.
I understand that, but it's, you know, they're,
Do we have a choice with the DNR?
I don't know, I'm just asking the question as my responsibility as a plan commissioner, as, you know, because if it was a stream or a river, it would be 300 feet. Because they're saying it's a pond or a lake, they're saying it's 1,000 feet. And I'm just questioning the reasoning and the logic behind how this occurred, whether it was man-made, whether it was natural, and just, you know, to determine, you know, just the slippery slope of, you know, when we plat new subdivisions, we're creating all these stormwater ponds, and I don't want, you know, somebody to come back 20, 30 years later to say, oh, oops, you don't have town zoning on this stuff anymore, it's all gonna become shoreline. So I'm just raising the question as part of this discussion.
Mr. Chairman, may I address that?
Sure.
Per statute 281.312M of the Wisconsin State Statute, stormwater retention ponds are exempt from shoreline zoning laws being established.
Okay.
So this may have been man-made, but isn't technically a stormwater retention pond.
That's correct. Man-made ponds that have absolutely no hydrological connection to any navigable waterway also would not be subject to that. So if you have a permit from the DNR to actually construct a pond, an artificial pond on your property, it would not be subject to shoreline zoning.
Okay, I just wanna
That's fair.
clarify that.
Sure.
So at some point in this process, right, with the determination of that pond as being navigable, the DNR has already made the decision on that, right? That's kind of set in stone. There's really no variance on that as to whether or not it met criteria before man-made or natural. They're saying that it's
Yeah,
the pond itself and the surrounding wetland all constitutes under a conservancy.
A navigable waterway that gives the county exclusive jurisdiction over the land for 1,000 feet in all directions.
I mean, we rely on the DNR, and they are the authority to determine the navigability of streams, rivers, lakes, ponds, things like that. They're the authority that we need to go by. We can't, I mean, our community can't determine, well, that's a navigable pond. No property owner can just say, well, that's a navigable pond. It's got to be the DNR that makes that determination, and they do it in writing. And I believe that there's some, a letter that was sent, it's been a while, but a letter that was provided that said that that's navigable.
And that goes to the first zoning change, when we gave exclusive jurisdiction to the county, and the county identified the different zoning districts, C1 overlay, EC overlay, and then A1, A2, and high groundwater. So now, the second change is to revert some of the zoning back solely to allow a driveway and a subdivision of the lot in the future, because that's not here today. And am I correct, Tim, our town ordinance would not allow a flag lot to be created by a CSM?
That is correct, yeah. We would require the frontage to be, at the 50-foot setback line, they would have to meet the 200-foot frontage. And that specifically was created to avoid these types of flag lots.
So if the town had kept jurisdiction over this property, the lot couldn't be subdivided. But now that the county has jurisdiction, it's up to the counties, and they've got a different process for waivers of road abutments or something similar to flag lot rules. And again, we're not making a decision, we're making a recommendation to the board to make a recommendation to the county.
Basically, the DNR has already made the determination, it's navigable, so
We're out of it.
So we're out of it, we just gotta throw our hands up and kind of take it?
Well, we could say we don't like this and recommend against.
And then we also seem to have the issue of not liking flag lots.
We do not like flag lots.
But they do exist within the town, so it's not like this is creating the first flag lot within the town of Delafield.
I'm not even sure this
Correct, but
creates
we
a
don't
flag.
want to, the intent was not to create new ones.
And that is,
That was-
if
It's
it
going to be a
comes back
flag, because
again,
it's going to be this
so
lot
if
right
this
here.
lot is subdivided, right, to sell off
And
the
a flag off of
second
this.
house, the existing house, does this come back before us again and we see the flag lot?
Well, yeah, it's
There would
gonna
be
have
a
to come back to the CSM.
It'd be a CSM, and again, we won't be deciding the CSM, we would just be making a recommendation for or against it to the county.
And in the meantime, with any decision here, we're basically approving the driveway as it meets for the zoning, with complications to, the existing complications noted by the neighbors.
Yeah.
I mean, one way to look at, I mean, I look at this as, the rezoning is for a driveway to a parcel, a second driveway. The owner has been very clear as to what his intent is, okay? If that lot was ever sold, I mean, someone could put in a driveway to put an accessory building on the larger property there, on the 11 acres. And, you know, if the CSM would not be approved, then potentially there could be an outbuilding that's there. And that's where that driveway could go to, potentially. I'm just saying that the driveway in itself doesn't guarantee that you know, the land split would be approved on that. We do have to approve the CSM, we have to sign the CSM, so it's not just a recommendation, it's an approval, but the county, we have to approve it and the county has to approve it as well. So from a rezoning standpoint, from a driveway standpoint, you know, it's a very small rezoning. It's not affecting the wetlands substantially. As far as this, it's a small percentage of the entire the larger wetlands. So from that standpoint, that rezoning, I don't have an issue with that rezoning. But the next step would be the land split, would, you know,
I thought
At
there
some
was
point in
something
time.
about spot rezoning too, in a town frowns upon spot rezoning.
do you want to address that, I mean,
Sure, that's a good question. This wouldn't be considered a spot rezone because it's being rezoned to A2, which is the zoning district adjacent to it, and how the rest of the area is also zoned. So if it were being, this is an extreme example, but if it were going from C1 to industrial, that would be a spot zoning. So this is just zoning to the adjacent district of the parcel.
And do we have it confirmed that we have it confirmed that there are existing easements on both sides of that portion that goes out to Sullivan?
So there was a 33-foot wide access easement created in 1989 on the north portion of where Tim's mouse is, there. And then subsequently the parcel, so that was before Mr. Suter's parcel was created via CSM. And that was done in, hold on. 6889. 7/12 of 1989 was the northern parcel. Oh, they were created at the same time. That's right. Oh, 1992, I'm sorry, October 26, 1992. So a few years later, Mr. Suter's parcel was created, and it's noting a 66-foot wide access easement. And the CSM does not show the temporary cul-de-sac bulb of Sylvan Trail. I'd say that this CSM isn't noting everything that it needed to. And just because it's not noted doesn't mean it doesn't exist anymore necessarily. It needs to have been released by the town, that temporary easement.
So do those easements provide any type of considerations that we need to be making in this decision? It seems like, at least from how those easements were, or the way that property is set up, it's overlapping the two driveways there, as well as that portion of the subdivision. Does that factor in here at all into essentially what we're being asked to rezone, or how we're being asked to rezone with regards to any applicability to those that hold those easements, whether knowingly or not?
So
given how
the
big word
13,
was?
so you're saying the 1,300 square feet of land that we're evaluating now, two other parties have easement rights over parts of that?
Yeah, I mean, if we're zooming in here, right, to the home that is directly to the south there, I mean, if we zoom in even more, that's cutting off that portion of their driveway, potentially impacting their access to it. And same thing with neighbor to the north, probably less so. But if you're bringing in a driveway at 66 feet, how is that impacting that potential driveway? And how is that not impacting?
yeah, the driveway that comes through here comes straight, I believe it comes straight off of here and then comes around like this. So there's the ability to have all three driveways at that point.
And the rezone doesn't change that.
Doesn't change that. The access, if this is an access easement of some sort, that doesn't change that as well. That should not be, I mean, the location of this driveway should not be affected by this access easement.
And I do want to caution just a little bit with our GIS, it's an overlay of platted boundaries on an aerial photograph, so there is, like, where the street is may not be exactly where the temporary cul-de-sac bulb is on the platted map, which is why we require surveys to be done, because it's a great tool, it's not 100%, and can always When you start zooming in really close, you're talking inches, it can get a little dangerous.
Yes, the question is, are we interested in making a recommendation for or a recommendation against the rezone?
Reservations about the rezoning of it. And part of it here, right, is we've taken an interest in the past of what neighbors have had to say, especially in some of these smaller neighboring disputes, and especially around water. So what we're dealing with here, at least in my opinion, is the fact that you have where we've gotten the designation already from the DNR, that it's navigable waterways, right? They're saying C1. And I'm sorry that from the town perspective, this falls outside of our jurisdiction, but you've got neighbors that are concerned about this and potentially already suffering some type of damage or impact to their property. Continuing with this based on what is now, right, there's always a timeline of how things have been handled in the past, what paperwork was done, when it was released. But at this particular point in time, we have that decision from the DNR that this is a wetland and that it does fall into that C1, right? That's where the county is pushing this. For us to go forward with this based on knowing that this could, or at least from the DNR's perspective, has been positioned as being sensitive area for us to move forward, knowing that there have already been problems as well with neighbors, that seems to put together a story or a timeline, a narrative that I don't think has fit in necessarily with some of the things that have been advocated in the past.
Ed?
I'm gonna just express a reservation. I didn't like the, you're not gonna be able to access your land comment. That was just something that was concerning as far as good faith and, you know, being, and just given the fact that everyone's so close, if this is approved. So that causes a reservation for me as well.
Well, I'm confused when you're saying the comment that he was landlocked on the.
No, the comment, basically, there was a discussion, and the discussion was,
Just
you're
granting
saying
this.
that we can't access our property, yes, I'm saying that I could block your access to your property. And so, and then, she's, you know.
Said
spoke
there were
as well.
easements, yeah.
Yeah, but it just, it causes me a concern with respect to,
Potential escalation.
yes, and just, you know, concern for other neighbors. I mean, it's not, it's a concern. In addition to what you're saying.
I just think there was a lot of knowledge that was dropped this evening that I'm still trying to process all the, you know, facts and figures. And I mean, from the, you know, the 50,000 foot holistic view, you know, this should be pretty straightforward. But, you know, and historically, you know, we haven't gotten involved as a town in neighbor disputes. We've asked the neighbors to work things out amongst themselves. So, I mean, I'm concerned. I mean, I'm still trying to process all the knowledge and everything, but it sounds like from what I'm hearing and have heard this evening in the public hearing is the DNR has made a determination that there is navigability on this pond. Therefore, Waukesha County has zoning authority of 1,000 feet within this navigable stream that DNR has determined. So therefore, because of Supreme Court rulings and everything else, the town has very little jurisdiction or say as to what happens with this parcel. And obviously, we need to trust our friends and our partnership at Waukesha County. And it sounds like Waukesha County is believing that they're in favor of, you know, based on what they hear from the town, of allowing this C1 Conservancy overlay to an A2 rural home district, to split this parcel. I'm hearing that there's 11 acres here, so you're gonna make two 5-point-some acre parcels. There is environmental corridor, so it meets the minimums of the 5-acre, you know, so just from the 50,000-foot view, the holistic, I mean, it should be pretty straightforward, and I think we should probably approve it based on the fact that the DNR has said there's a navigable stream. Because of the Supreme Court cases and everything, the town no longer has zoning authority. We're not creating, you know, a 3-acre parcel or a 1.5-acre parcel or a 20,000-foot parcel. I mean, we don't necessarily want to create flag lots, but,
Well,
I mean,
we actually have an ordinance against that. That's what
Yeah.
I'm saying. If this were to remain town jurisdiction,
it wouldn't pass.
the CSM would never happen.
Right. But we've seen with shoreline zoning that things have happened and have changed amongst the town because of the shoreline zoning. And the county taking the zoning away from the town, so, I think at the end of the day, I feel like my hands are tied, and, you know, I'm gonna make a motion to make a recommendation to the county on zoning the amendment, on a zoning amendment under Waukesha County Shoreline and Floodland from C1 Conservancy Overlay District to A2 Rural Home District.
Can I ask one question before you do it?
Sure.
So, positive recommendation option, negative recommendation option, is there a no recommendation option? I'm just curious, because it just says positive, and so I'm just wondering what the options are.
That's a fair question.
Our ordinance does seek the town plan commission, specifically the town plan commission's input on all rezoning. I can't think of a time where a town has just decided not to take action on it.
Or,
I just
or it
didn't
could
know
be
what
a
the option- I
neutral
just saw
vote, could be,
positive, yeah.
it could be
It could be.
our recommendation is, we don't have one. Who's voting tonight? 1, 2, 3, 4, 5. We may not have.
Maybe you can
Well, but it
clarify.
sounds like, in some respects, though, it sounds like the county's making this call regardless.
They're just
It's-
soliciting the input
it's-
from the town.
They're
and, you know,
soliciting our input, so
We
we've,
want to incorporate, it's your town, we like to incorporate your standards and opinions where we can under the ordinance, right? For example, the creation of a flag lot, understandably so, and that's I didn't know that until this came up. That's good to know that you discourage that, so we can aim people away from that to the extent possible. If that didn't exist off of Sylvan already, I think that we would be in agreement, that no way, you're creating a brand new, flag that is from open agricultural lands, and that's something that we also don't, love to see. And setting the flag lot portion aside, I just want, to also bring up that obviously we, are looking at wetland and waterways very seriously in our office, as it relates to fill around them. This is a pretty unusual rezone. I've never even had a C1 rezone before in my almost 8 years at the county. So it doesn't happen very often, that we see in these unincorporated areas. And Mr. Suter has, within the last 5 years, 2017, 2018, there is documentation of previous permit history. However, I find it to be a little bit of a loose path, and if the county does recommend approval, I would like to make sure that all permits are current, and for the areas, as part of this rezone, again, remember the one on the north portion of the driveway has already been done. But I do think that the drainage, or the flooding concerns of your property are very valid, and Blake actually did make a comment, going out there one time, there was some flooding issues to the north of that culvert. So that's something that we would reevaluate. Even though it's done, doesn't mean that, things can't be modified in accordance, as a condition of the rezone, if it is to be approved.
You could also reevaluate whether those other two property owners actually do have easements or access rights. 'Cause
Yeah,
I wouldn't want to
generally-
lock them out, and I didn't appreciate that comment.
Absolutely, as part of a certified survey map review, that's something that we can evaluate and make sure that there's certain notes that are on there. We do that research as well, and ask that the surveyors conduct that research and provide the documentation
And that's all at the county level, all those restrictions and contingencies and stipulations would be at the county.
You have, so if you make, if you recommend approval, if you put conditions on that approval, we carry those through. So if you, for example, recommended approval subject to, DNR, Army Corps of Engineers, and county stormwater and planning and zoning permits being applied for and obtained that are current to this proposal, kind of thing, that's something that we would carry through. We might modify the language a little bit to actually state the correct ordinance or something specifically, but that's.
Would you be willing to modify your?
Yeah, I would like to modify my motion to incorporate with the recommendation of approval to ensure that all necessary permits from the DNR, Waukesha County Stormwater, and the Army Corps of Engineering regarding the wetlands are all current and up to date.
And the easements are all.
And the easements are all up to date and noted and recorded.
With that, I'll second that motion.
Any further discussion? I think a number of those conditions will be on the CSM, not on a zoning change, but I don't think it hurts to have them as part of the motion.
Yeah, that's why I didn't include them in the motion, because I figured that would be part of the CSM.
We're just giving direction to the county. We're like little children here.
That certainly can be included as a condition of the rezone.
Oh, they
So
can?
it can be, if you would like, it can be a part of your motion, and the rezone is conditioned upon that. So that rezone is conditional until all those permits have been obtained.
Yeah, and that's what the motion, that's how the updated motion that I just made.
Yeah,
Okay,
yeah.
yes.
The permits and the easement issues.
But the easement issues are on the CSM, not on the zoning.
Yes, generally.
Okay.
But it, I mean, it could be evaluated, that's.
I don't want anybody cut off their property. I don't think anybody does.
Well, frankly, I don't even want the threat of it. You know, it's like, that's, you know.
That barn door is open.
Yeah. I guess one question is, how do we ensure, based on what everyone's saying, as far as if there are water, does this ensure that if there are water issues that impact the neighbors, that they're addressed?
We have to trust our friends at the county to,
Okay, I'm just,
That is now my job.
all right,
And Rebecca's good.
I can tell she is.
Okay.
I just want to make a comment about, I think you were talking, Edward, about, you know, the recommendation to the county. It does hold water. I mean, if we would be against this, I mean, they would take that back, and I think they would take it seriously, you know, so it's not like we have no option here. We can deny the request, and the county may do whatever they want, or they may take us seriously and say, if the town doesn't want it, then they won't do it. Is that correct, I would say?
Yes.
I mean, I just don't want everybody to feel, well, we just have to do this. I mean, there is an option not to rezone this, and the county can overrule us, or they could take what we say and incorporate it.
yeah, this isn't the property I'm gonna take that stand on, so
Okay.
I'm sorry.
All right.
Any further discussion? All in favor?
Aye.
Aye.
Opposed?
Nay.
Failed 3-2?
I thought it passed.
No, it passed 3-2.
Passed.
Because you were an aye,
I was an A.
oh, you were an A?
I was an A,
I was an aye.
Oh, so it failed 3-2 then.
yeah. But you're not voting tonight. You get to vote next week on this. Okay, so we're yeah. Well,
So it failed.
So that failed, but then do we want to pass a negative recommendation motion? Rebecca, do you want the reverse motion then, or is the failure of this motion sufficient?
I would think it's sufficient. Yeah. But we'll give you,
Unless someone was making a change to that motion to add additional recommendations or additional conditions or something. I've seen that.
Does
before,
anyone
just a
wanna-
Modified approval to incorporate more assurances essentially.
Does someone want to make a motion to just not recommend this to the county?
Well, I think you not voting yes to it is the recommendation not to.
Yeah, you can't have a
Otherwise,
negative
it's a negative motion, and so I think the motion speaks for itself.
Okay. Item 6, discussion, none, thank God. Item 7, announcements and planning items, next meeting, Joint Plan Commission and Town Board training. Next week at 5:30?
Correct.
Next week at 5:30, so please make it if you can. It's going to be both training on ethics and other Plan Commission requirements and state and local ordinance requirements. And then we're going to have a closed session discussion on some items that'll be discussed next week. And then the next regular meeting of this body will be July 12th at 6:30. So a week later in July than normal because of the 4th of July.
And Dan, I don't know if you wanna know how to out of town, but
Yep, I got your
Okay,
email,
got
so
it, okay.
Ooh, you're gonna
you
miss
should
it.
watch it from wherever you're at.
You're going to want it.
Motion to adjourn?
Item 8, thank you. All right. All in favor? Go
Aye.
home.
Who seconded that motion to adjourn?
I'll second it.
Okay.
I really didn't wait for a second.
All right.